Hello, everyone. This is Katrin with Disability Rights New York, and welcome to our podcast, Empire State of Rights Closed Captioned. We are here to bring you the most relevant topics regarding disability rights and advocacy. Today, we have Jennifer Monthie, the legal director of DRNY, here to discuss an upcoming oral argument before the U.S. Court of Appeal for the Second Circuit in DRNY v. New York State. Jennifer, can you tell us what this case is about?
So Disability Rights New York filed a lawsuit against New York State and the Unified Court System. The lawsuit focuses on Article 17A of the Surrogate Courts Procedure Act. And under Article 17A, a court is permitted to appoint a guardian over a person with an intellectual and developmental disability. What DRNY is alleging in the claim is that the statute violates the Constitution because it denies people with intellectual and developmental disability due process rights and equal protection. DRNY is also alleging that 17A discriminates against people with intellectual and developmental disability. Fundamentally, DRNY is asking the court to look at the way that New York State appoints guardianships over people with intellectual and developmental disabilities and see whether it affords enough protections to ensure that that person's rights are protected and a person is not unnecessarily placed under guardianship.
Guardianship is a pretty complex issue. Can you tell us exactly what is guardianship?
So guardianship is where a court transfers the decision-making rights of a person to another, and those rights are rarely regained over the lifetime of a person. A guardianship under Article 17A is a total loss of decision-making authority, meaning that somebody else is given the decision-making authority of that person. And almost always it's permanent, which means that it's for the entirety of a person's life. So a person may be placed under guardianship at the age of 18 when they reach the age of majority, and they may stay under that guardianship with someone else making decisions for their entire life.
Okay, so where is this case right now?
So I'm going to take a step back because we've got a little bit of procedure to get through. And I apologize to anybody who's not a lawyer listening to this because I'm sure this is like listening to, I don't know, or watching paint dry, I guess. So on September 21st, 2016, DRNY filed a lawsuit. And the lawsuit was in what's called the United States District Court for the Southern District of New York. On August 16th, 2017, so little less than a year later, the Southern District of New York dismissed the claim, saying that it would abstain from hearing the case because DRNY should file the case in state court instead of in federal court. So federal courts sometimes abstain from hearing a case when they decide that the parties could have brought their concerns before another court, and that's really what the district court did in this case. DRNY appealed that decision to the Court of Appeals for the Second Circuit on September 11th, 2017, and now the case is pending in front of that court, the Court of Appeals, and oral arguments are scheduled on whether that district court did the right thing from abstaining to hear the case on August 16th of this year.
So this certainly isn't a quick turnaround of time for this case. Will the Court of Appeals be able to stop the New York courts from appointing Article 17A guardianships?
So not at the August 16th oral argument date. At this stage, no. There's only two issues that are being considered on this appeal. The first is what I talked about before, is whether the district court was wrong to abstain from hearing the case. The second issue, which I've not mentioned, is that when Disability Rights New York appealed the dismissal of the case, the defendants for the first time raised a question as to whether Disability Rights New York is the right party to bring the court case. This is referred to as standing. So in order for someone to bring a lawsuit successfully, they must first establish to the court that they are the right person or entity to assert the claims. And in order to get to the merits of DRNY's claims, this will need to be remanded back to the Eastern District of New York from the Court of Appeals.
So when you go to do the oral argument, is this a public venue? Who can attend?
So anyone can attend an oral argument. Anyone can attend to this one. I have been hearing people inviting people, so maybe we'll have a large crowd there. The argument is set for 10:30 on the 16th at the Second Circuit Court of Appeals, which is located in New York City.
At the end of this argument, will you know the outcome?
Unfortunately, no. We all have to wait. I will have to wait. The court is going to issue a written decision. So, yes, we will be waiting, and we may be waiting several months for the decision.
Well, we can't wait to hear how this turns out. Thank you so much for your time today, Jennifer.
Thank you.
Empire State of Rights closed caption has been brought to you by Disability Rights New York, your source for disability rights and advocacy. If you enjoyed our program, and we hope you did, make sure to subscribe, like, and share this post. Tune in next time where we'll bring you more information on disability rights in the state of New York.